Hi students, topic 4, the start of the justice system. The first topic is alternative dispute resolution. This is the option, rather than going to court, you may be referred to some type of ADR, or in fact going to a tribunal. These are mainly used for neighbourhood type disputes or low-level disputes of a civil nature, similar to the small claims court. They impose different types of outcomes and they're not always binding. Direct party control is where you control the matter from the start to the finish, and there are 4 main areas that you can have for direct party control. An example could be putting up a fence around a block of land. If your neighbour puts up a fence that you did not agree with, nor do you want to pay for, or you weren't consulted, they're in breach of the Fencing Act. So the first thing you can do is go over for self-help, and you negotiate with your neighbour, maybe to pay a lesser fee or do not pay at all. The danger with self-help is it can escalate the matter, could become violent, and for some people, relationships are fractured. The other option is, you might not be happy with the fence, you get sent the bill, and you just abandon the claim in the sense that you just pay it. The other thing you could do is you could concede, is that you agree that you both need a fence, you come up to a reasonable price, and you concede to the claim, and you settle the disagreement. Lastly is consensus. This might be where you come to a negotiated price, such as 60-40 or 40-60, and that allows the relationship to be restored and you to move forward. As with any type of direct party control, that depends on the person. Some people are really confident with this and are able to negotiate with their neighbours, their friends, family members, contractors, but for some people it can escalate the matter and make things worse. Sometimes things move away from self-help, where a third party might be required for mediation, conciliation, or arbitration in a tribunal. It's really important to note that mediation and conciliation are voluntary actions by both parties. Even if decisions are come to by both parties, they are not enforceable. But arbitration is similar to a court or tribunal where decisions are made which can be enforced. So ADR is the option used for most civil disputes. About 90% of civil disputes are settled through ADR. In criminal law, an example of ADR would be looking at different offences charged and negotiating the most serious charge, and maybe through plea bargaining not going ahead with the minor summary offences. An example could be a stolen vehicle. The person's caught speeding, the person's caught drink driving, but the stealing of the car or the stolen car is the indictable matter. You might just proceed with the indictable matter and not go ahead with the speeding nor the drink driving as a way of plea bargaining, which is a part of ADR. This is a past exam question on ADR, and it said, what are some examples of resolving matters rather than going to court? If you were to give 3 of these and explain them and give an example, you would have obtained 6 marks. You did not need all of them, but you would have needed at least 3 to obtain the maximum grade.